famous American author Joyce Meyer once said, teachers can change lives with just the right mix of jobs and challenges. Now, with this quote in mind, I, Tanushri, on behalf of CMR University, School of Legal Studies, welcome all of you to the CMR University 7-day Faculty Development Program 2024. I would now like to request our respected Dean, Professor Dr. T.R. Subramanian, sir, to present the welcome address.
A very good morning to all of you present here. I deem it a great pleasure to invite Madam Professor Dr. Shashikala Gurpur. She is a well-known scholar, known not only in India but even abroad. Her contribution is immense in the field of law. And you know, you have seen her CV and her profile. And she served as a member of the Law Commission. She is holding a chair at present, and she served in distinguished capacities as well. Currently, she is serving as the Dean of the 4 law schools created and established by the Symbiosis International University. This is the first part. The second part is why FDP. See, we are living in an era of globalization. In an era of globalization, it is nothing but knowledge economy. Everyone, especially teachers, have to update themselves with their knowledge. Now, yesterday's knowledge maybe does not hold water today, but then today's knowledge may be good today itself, by tomorrow. That is why in most of the universities, syllabus revision used to take place once in 3 years or 5 years or 10 years. There were hardly any revisions. But then it is not the case now. Every year, syllabus is being changed. See, the development which have taken place after 2013 in this country is immense. That is why most of the universities are going global. You may be knowing, few of you at least know, the type of MOUs that are being signed with the Western universities, the kind of steps that are being taken to go global. The very purpose is, remember, we have a huge human force. And this human force, remember, are able to do any type of work anywhere under the sun. And it may be the top job. And it may be the menial job as well. And they are able to do it. So in situations like this, we have been doing what we call the FDP program in the last several years. And this year, it begins with Madam's lecture. Thank you once again.
I'm now extremely delighted to introduce our guest speaker for the inaugural session, Professor Dr. Shashikala Gurpur, a distinguished academician and orator. Dr. Gurpur is the Jean Monnet Chair Professor 2021 to 2024, EUC-LAMP, co-funded by the European Union, and a Fulbright Scholar. She serves as the Director of Symbiosis Law School and Dean of the Faculty of Law at Symbiosis International Deemed University, Pune. Having received her formal schooling in Kannada medium in Gurpur, she holds degrees in science and law from Mangalore University. Dr. Gurpur received Ph.D. in international law from Mysore University, where she was also the topper and gold medalist in LL.M with 3 gold medals. In the backdrop of long years of experience in legal literacy and gender training, having worked as co-director in gender and human rights-based wing of an NGO for 2 years, she has also worked as HR manager and administration in MNC, Abu Dhabi, UAE from the year 2004 to 2007. Ma'am has delivered over 325 invited lectures, workshops, and seminars across the globe, including India, the US, UK, Germany, and Australia. She's a pioneer of European Union legal studies in India and with an extensive experience in teaching, research, and industry. She has been with Symbiosis Law School since 2007, significantly contributing to the legal education and research. I would request our Dean, sir, to present a bouquet to ma'am as a token of our appreciation.
Good morning, revered and respected senior teacher, Dr. Subramanian, sir, the Dean of this law school, the leadership team of Dr. Pranesh and Srinidhi and others, and all the dear faculty members who are here, and all the faculty members from across India who are connecting online. It's my uh, it's with immense pleasure I start speaking here as the first speaker among all the panelists who are going to enlighten you on the new developments in criminal law in India. At the outset, I would like to share with you the greetings of Guru Purnima because it's a very special day that has just passed, where the day of the birth of the person who unveiled the knowledge of the Vedas, Vyasa, Veda Vyasa, he was called as Veda Vyasa. So all teachers are supposed to be unveiling the knowledge all the time. And this knowledge comes to us from our experience and from the mouth of the senior teachers and today with a lot of other resources. But Vedavyasa started that culture of documenting the knowledge which was otherwise dispersed in many versions. Today in India, when we are talking about criminal law, something similar is happening. That it was happening at least. We all thought Macaulay's code was infallible and it was timeless. This thinking, I always soul search myself, and all teachers have to do that because that is the discursive power of the authority, the West, the colonial hold. And as Sir was giving his address, Dr. Subramania mentioned about in today's globalizing world, the India is the home to huge manpower. Yes, how much of it? 65% of young population, whereas rest of the world is aging. So it is our people, our youth, who for next 30 years will be the resources for the world, rest of the world, which is aging. But then have we readied our youth for this golden opportunity? 200 years ago, America had this opportunity when so many universities in America evolved and America became a force to reckon with education. So much so that even our young people want to migrate to America irrespective of their duty towards the country which has paid for their education. Now, globalization is not new to India. India always was in the lead in terms of being open to all cultures, providing shelter to anyone who came. Even during the Second World War, despite being under the colonial stranglehold, India was the home to the Jewish people who were persecuted, escaping persecution in Germany. India were home to the different religions which were facing persecution at their own home or religious leaders. So India, and right now also we have a living example of the Dalai Lama. Why to speak of anything else? And thousands of Tibet, now lakhs of Tibetans who are with us, for whom India is the home. So let's be very proud of what we are doing. And this criminal law rechristening or renaming with the three legislations, the Bharatiya Nagarik Samhita, the Bharatiya Suraksha Samhita, Nagarik Suraksha Adhiniyam, Bharatiya Nyaya Samhita, which is the word, the Nyaya Samhita, and the Bharatiya Nagarik Suraksha Samhita. So the three, Saksha Adhiniyam, which is Evidence Act, Suraksha, that is Criminal Procedure Code, and Nyaya Samhita, which is the Penal Code. We didn't want to call it as punishing code. We want to call it as justice code. This is, see how the anguish and the aspiration of this earth is. Because if you look at the tradition, as Amartya Sen himself pointed out about the distinction between Nyaya and Niti, we were always looking at justice as the outcome. How you do that justice if somebody is going out of control, misbehaving? We did not resort to this kind of extreme means of prisons and trials and things like that. So in a way, human behavior, the way it has evolved in the last 300, 400 years in the Indian continent, could also be as a reaction to this kind of Puritan, Victorian, church-based, limited kind of approach rather than the communitarian approach, which is very strong in Asian culture. So, although I have my own limitations in terms of analyzing criminal law because my field is different, I have made a very humble attempt to look at this whole change or the whole embodiment of criminal law from the point of view of a universal value, which is justice, and embedded within the justice as the value is the human rights. Many times we condemn criminals that is on the one side, or accused, we condemn. On the other side, the state assumes power as if it is unlimited power to treat this condemned criminal. We should read outside of the law to look at what kind of unbecoming of justice it has been. Yesterday, I was in Mysore with a number of writers. I was introducing to very young students the idea of feminist thinking in some of the writings and how it cuts across the vagaries of power. So one of the important writings was Mahashweta Devi's Dopti, which was about this tribal woman who escapes persecution, who somehow survives that gunshots by the special squad, and then she runs in the forest. Somehow, they become helpless, they won't eaten for any days. So she gets caught. And the way her body was abused by the army, and the way she captures in that powerful narrative, and how it ends in Draupadi's protest, which was called Dopti. So these are all the indications of how our existing code and black and white approach in criminal law has been it has not been very healthy. It has not been serving the end of democracy or a just society because state assumes unlimited power because state is the main actor, right, in criminal law. All offenses are wrongs against the state. So state assumes unlimited power, although the constitution tries to limit this power by reminding the citizens' rights in part 3 in fundamental rights. I hope as senior faculty and advanced learners and faculty members, all of you online and offline will agree with me. So I commend this CMR Law School's leadership team for thinking of this faculty development program. Second prelude I want to make is in terms of recent developments which have been happening. Somebody was asking me, and most of the press people, they want to have a quick fix to every deeper issue. So is your law school going to revamp the syllabus? Such a silly question they asked me. I said, no, our nomenclatures are strictly by the Bar Council of India. I hope all of you will agree with that. We don't change our Indian Penal Code right now. We have as criminal law 1, criminal law 2 or 3. Many make it into 3 papers, many make it 2 papers. So can we call it as Bharatiya Nyaya Samhita 1, Bharatiya Nyaya Samhita 2? We can't because Bar Council hasn't changed the nomenclature. Bar Council probably will give us a new set of rules. Or Bar Council itself is a questionable authority on legal education as far as current discourse goes. So, because we have National Medical Education Commission, so hopefully we'll have a Legal Education Commission. But in the run-up, we have to respect what Bar Council has given us as a course nomenclature. So, how do we incorporate it? So I am going to share a very important document with Professor Subramanya, which I think experts like Dr. Pranesh and Dr. Srinidhi will have to help with in culling out that table where we have corresponding sections and color-coded version of what is deleted from the old code, what is altered, and what is new. If you ask me, the percentage of new is very, very small. So I told the press, I can't answer the question whether it is revamped because the beautiful thing about current law is it is indigenized, it is Indianized, not only in the name, somewhere deep inside, if you see all the words like Her Majesty, His Majesty, the Crown, all that King's language has been totally sanitized, which is asserting our identity as Indian nationals and Indian citizens, which I see as the first step towards bringing law closer to our hearts. Maybe that is the reason why violation of law is considered as violating a foreigner's privacy or something like that, because people haven't allowed that law to pass into them. They say the law, okay, I have to ask the lawyer, as if it is only our domain, law teachers and lawyers' domain. It actually, law and justice are part and parcel of one's existence in a society because democracy cannot be spelled out without rule of law. So that is the important observation I want to make. Third observation I want to make as we go progressively in this one area that I have taken, you will see that the entire 3 legislations have tried to spell out our own experience in terms of our realities confronting this colonial code in the post-independence period with our questions of justice. Like, for example, some of the non-governmental organizations confronted in the independent thought judgment the issue of child rights, especially women who was married at a very tender age. And the binary or rather ambiguous way in which a woman's religion determines on how her rights are spelled out in case of permission to polygamy and or permission or option of polygamy under the religious framework which governs the personal law, but allowing them. Something like 125 under former CRs, which talks about maintenance, but because in conjunction with the personal law, it gets spelled out differently in terms of reaching the justice to the needy. So all these ambiguities have been dealt with in the light of various Supreme Court judgments which have come. Another very important point I saw was law commission's past work, whether it is in 498A or whether it is in very important one was gender neutrality of rape, which Verma committee also could not do because Verma committee was the backdrop of Nirbhaya case and it had to be in a gendered context with Leela Seth and all of them. So gender neutralizing the rape is a very important provision. And the fourth one, which I would like to point out, is 377, the decriminalization of same-sex relationship, sexual relationship. That, of course, then it is spelled out in terms of what you call as, that, of course, if there is gender neutrality of rape, then that complements. Otherwise, keeping rape as gendered and then 377 being neutralized. So both may have contradictions within the laws. This has been addressed. And another very important point I would like to point out is where, which also I consider as a very important development in case of children and women related issues which are coming in. So one of the questions that people will ask is whether those specific laws which we have, will they be affected? For example, in-camera proceeding earlier was mentioned and then it was brought into the frame of court proceedings and rules. Now this has been given a statutory framework. We didn't have that framework, right? You were teaching in the class. You were teaching in the class based on what you were updating from your books and other sources, or maybe some of you had a background of practice, so you did that, right? Online also. Some of our colleagues would have a background. But today, when it comes into the framework of the law, it assumes that application. There are many things. For example, witness protection scheme. My one colleague has done a PhD on that, whistleblower and other things. And when he did that PhD, he was always having discussion. Professor Abhyankar, very good book he has written. Taylor and Thomson Reuters has published his book also. His PhD has been published as a book. Today, if you see in witness protection scheme, the legislation insists that all states should have their proper scheme. Because again, when centrally something is passed, law and order is under the state jurisdiction, and they have a tendency to ignore for political reasons rather than the justice reasons. Or maybe just the evolutionary stage of many states in terms of some states have evolved also recently. So these diversities have been in a way unified and addressed, and that idea has been emphasized. So that is the positive. Within the limitation of time, I cannot spell out everything. There was one more provision I wanted to, maybe I will proceed with the slides, so you will be able to capture it. I'll be able to connect it better. I have a whole lot of some 90 pages document, which I request you to segregate from the mail because the main text has come from a very confidential source. Large number of resource persons have come together and done it for before all of us, the courts have to be ready because the minute the legislation is passed, cases are registered and court has to be the new court, right? So they have done this work. So and which is very important because tomorrow, as Sir said, whom we are addressing, whom we are producing at the end of the products for our legal system, right? Court system, different careers with the court centricity, and even in law firms. Recently, we had the CII, and part of that committee is Mr. Lalit Basil, Society of Indian Law Firms. So we had a law firm person, incidentally a old student, one of my colleagues, and CII people, Lalit Basil himself. So now they have practice, law firm, and academia. The discussion was held. I assisted that teacher with this material, so she was able to give a good show there. So what we are seeing is this kind of expertise material should go to our classes. You guys can, you are experts, you know the art of conveying it in. So if you are able to build the capacity in your students, this is the capacity building for you, so that you build that capacity in students. So I wish this everybody all the best, and I wish that the whole learning that you all are going to have under your institute's leadership will benefit the whole community of law teachers who are connecting here from outside as well. So thank you, sir, for giving me this privilege, and I will continue with the session that I have planned for. A little prelude to this session. This session is named as, if you can go to the first slide, the session is named as Human Rights Due Diligence in Criminal Law. We do this human rights due diligence at two parts. One part is in terms of the object whom we are addressing, normally the victims or survivors of crimes. The second part is the process of criminal law. So this part of my address is predominantly looking at process, because that is something that judges usually have to follow, the capacity which our students have to build, because they will be tomorrow's lawyers, they will know the mind of the judge, and they will have to, as the officers of the court, they will have to see that if the judges are not very enthusiastic, or they are not predisposed to do this, then the lawyer as officer of the court can inspire those judges. You know that in this country, if law has made such strides to challenge Macaulay, it is only because of the way in which our eminent lawyers at all levels and our judges and our judicial academies, once again, under the guidance of late Dr. Madhav Menon and many other jurists, which has been possible for this stride. So today we are standing with our own strength in renaming our laws and gearing them to the experience, the distillation of the experience that we have gathered through our evolution in terms of judicial wisdom, judicial process, administration of justice, with both, because our constitution has made strict separation of powers, there are overlapping areas, and collaborative areas. Criminal investigation is one such area. Executive is that. You know, the interesting thing is judicial process is by experts, because bar council has standardized norms, then registration is standardized. Unless you have a law degree, you can't be a lawyer. Unless you are a lawyer, you can't be a judge. But do we have the same in the executive? Even an ordinary constable will be dealing with the case in some manner, though peripheral. And the officers, from case to case, it varies. They don't update themselves in legal knowledge. Their training academics don't have a very consistent training. So this government has brought up one university called Shashikala University in Gujarat. And then I also was involved in giving a proposal about professionalizing the police force, which is the dire need of the hour, right from the constabulary level. You know, if you read more, you will see that in Korea it is done, in France it is done, Netherlands has the highest level, UK, everywhere it is there. Where is our professionalization of the police? Police training academy trains the police in the skills. But is it training in that multidisciplinary approach? Now the forensic training is mandatory, because here forensic evidences are allowed, and without the forensic evidences, no FIR can be going forward and no charge sheet can be finalized. That's why you would see in Karnataka's sensational Darshan case, so much of forensics is being discussed, even in the media and experts are talking about. So the incriminating, clinching evidence has to come from the forensic and DNA and other scientific means. And e-evidences and digital processes are also integrated into these codes, which Macaulay wouldn't have thought also, dreamt also of in his wildest dreams. So I'm very proud that we are today discussing what is Indian, authentically Indian in many ways. But we could also do more authenticity, which would come maybe You make the first attempt, then you can build around that, right? So I hope it's clear to you. Due diligence or investigation or critique of the criminal law in terms of human rights, there are many facets, but I'm taking only one facet: fair and impartial investigation. So how do you define fair and impartial investigation? Where our internal laws are dealing with it, and what are the parameters or yardsticks with which we define and correlate human rights and criminal justice process? Let's go to the next slide. What is investigation? What is investigation? Now, I think I can go further. If you look at the investigation, let me take an example. How many of you are Netflix viewers? Without the mic, I think online. Yes. Yeah, but I can't see the person. Yes, I can keep that laptop. Laptop. Yes. Yeah. So the credit that I want to take, how many of you Netflix watch? Small number, big number. So in Netflix, anybody has watched the Innocence Project? Innocence Project is about, how many of you know about Killing the Mockingbird movie? Good. It's an important human rights movie you should show to your children, students. It was made into a movie, but before that it was a novel. It is about a lawyer, white lawyer, who defends a black man's criminal allegation, so they made a museum in Southern America, in that Mississippi area, about this Mockingbird Museum, in the Mockingbird Museum. The Mockingbird Museum has got all the annals of the whole struggle of Civil War, American Civil War, etc. But Innocence Project is about a Harvard graduate who, motivated by his human rights law professor, goes through these files of the people on the death row in this area. And almost all were blacks. And there was some kind of a question raised on how the investigation was done, how they were sent to the death row, on the basis of which evidence. So Innocence Project, for example, takes up one case, which I watched in detail. There were many cases, I don't have that kind of time. But my son is the one who inspires me to watch this. So what happens is, there is this young man who was accused of raping a young girl, and her body was found in the nearby lake. And then they found the body to have many marks, and particular type of teeth marks on her thighs and on her body. So they had seen this boy interacting with that girl. And then there were many other incidents which they connected, they incriminated. So he was in the death rate. Now the clinching evidence was this tooth, the bite marks. And the bite marks, the size and shape matching with this predominant incisors in the front two teeth. So finally, this professor, this student guided by the professor, he goes through all the evidentiary process, and then he sees that the clinching evidence from this periodontic expert, the dental expert, and this dental expert, he interviews, and then he interviews some other neutral dental expert. And then the neutral dental expert says that the chances of that dental mark being there, even after the body was rotting in the lake, is very remote. But then they wanted to somehow connect the two, and then they have incriminated. Now, because of the contrary statement, which brings uncertainty, we have a principle: let 1,000 guilty escape, one innocent cannot be punished. That's why it's called innocence file. So to get him out of the death row, this clinching evidence was contested. And then finally, it was very clear that there were certain fish species which were living in the lake, and they had a sucker in the mouth, which matched with the size and the shape of this mark, which allegedly was a dental mark from a black man's tooth. So, on the basis of that doubt, he was exonerated from the death row. But by that time, so many years he had to languish in the prison, the major years of the youth were spent. So the state's liability and the question of compensation, human rights violation, that's a separate issue. That will come later on. We know that. And that is exactly where you see that investigation in terms of being the inquiry into the matter systematically. And the word investigation, what is invested there? What is invested is power. and authority. So authority or power supplied to inquire into a matter systematically, it's a process or circumstance surrounding an allegation or an incident. That's laudation. Then if you go ahead in our current NSS, National, what you call the Suraksha Sanstha, Bharatiya Suraksha, not B.Sc, Bharatiya Suraksha Sanstha. In that also, same definition has been retained in section 2. All the proceedings under this code for the collection of evidence conducted by a police officer or by any person other than a magistrate. See, strict separation code. Other than, because magistrate becomes the authority who will ensure that there is fairness. Then you can't be the judge in your own cause, right? So that neutrality is maintained, who is authorized by the magistrate on this behalf. So either initial officer or magistrate can authorize. You know that in the criminal procedure code we have the option for the reinvestigation, de novo investigation, and then we also have a provision for private complaint, because of which magistrate can instruct. So these points are taken into consideration in section 2H as synthesizing the definition of investigation. So what is fair investigation is the next question. Yeah, yeah. So, so it's not just the matter of the police. There is also investigation leading to the trial and effecting the trial and the fair outcome of the trial. So we can't say that police have only the investigative power. That our police are only for investigation. What we forget is that it is going to be the building block for the fair trial, the fair outcome. So it is the first step in justice delivery, which police don't seem to have any clue about. I'm standing before you after having gone through the pain of working with the police on a personal case with a close family member, and the way in which the survivor or victim's participation is zero in the trial. But today, with the new amendments and all of that, it is not just a recasting, it is also amended version of our criminal procedure code. So there is a victim-centric approach that is taken. So victim has to be given the copy of the FIR. These are all insisted upon. So I'm going to give you that comparative table. All of you will find it in one glance what to be focused, some which is deleted. So the addition is this, giving the copy of the FIR, zero FIR. We had recommended this, if you remember, I was telling you about that. So many of the rights implicated emanate from Article 21 of the Constitution. Due process of law, life and liberty. So these cornerstones of Article 21 are embedded here. And then we have the case law and domestic provisions. And we know that Supreme Court has provided many provisions regarding protection of the rights of the accused person. And we know that in international law and comparative jurisdiction also these rights are protected. Let's go ahead. For example, I had this case from England where anti-terrorism law in England also it is quite a strong law. So investigative powers are unbridled. So they would enter the houses of people and check for this. This is always exaggerated and abused because most of the time those who are involved are economically considered as burden. Let's mindset continue, coupled with that racism and otherness, this assumes a very inhuman proportion. That's why this whole idea of fair trial and investigation is a very important cornerstone of justice sense in the criminal law, coupled with human rights. And we know that in the investigation, arrest forms an important part. I mean, you have to take into custody the accused. And what are the different types of rights available at the time of the arrest also is very important. So when we teach, let's not teach in a mechanical manner. Let's read it with the human rights and constitution as we go further. So the procedural safeguards embedded in the constitution as well as criminal procedure code. I will tell you a story. In the early 90s, a boy was arrested in the evening when he was coming home in a junction. A couple of days before, the inspector had stormed the local authority. He was a local area. He was a new inspector who had taken over, and he hated these youngsters hanging out together. So he would go house to house, door to door, and find out how many of you are hanging together. And he would go and threaten these households that if your boy goes out, I may take them into custody. So he was one person whose report used to come to my ears. That he was almost in that emergency frame where the state has absolute power. But we ignored because it was not connected in any way. This boy was coming home at 6 o'clock and he had parked his bike. He was purchasing something, sweets or something to take home. Order was done, and then the police come and catch him and push him into an auto and take him. Now, the sweet shop person calls, those days no mobile phones. He calls the landline number of the parent of the boy, and then the whole gang of boys, youth in Bangalore and other places, went to the police station. He said only one thing: I have my control of the kingpin. I am not going to leave him. What was the role of the kingpin? Kingpin never went and shared any activities that other boys. Other boys also were not antisocial. They were just being together. This police officer's theory was if 10 youth come together, they are always going to be antisocial. People hang together because maybe human being is a social animal. So this sick mentality. So what he does next is he does not leave this boy from his custody, doesn't listen to anyone, phone calls come. He says, the more the phone call come, I'll have to bash him. So people didn't want him to be touched, and nobody had the idea of rights also. So one of the boys alerted me, and other people did not allow me to enter the station. It was by about 10 o'clock that I came to. 7 o'clock he was taken. So 10 o'clock, when I tried to go, all the elders who were in the place, the boys, relatives and all, they stopped me from entering the station. So I didn't know what to do. We kept the car there, taxi there, and we waited. We came home. And then at about 12 o'clock in the night, after 2 hours, I suddenly got a sense. I told the driver, let's go. And that elderly man said, I will also come. So we went and we entered the station. And to our surprise, this inspector who said, I have an urgent work, I'm out, jeep was there. So he had come with that sadistic mindset. And when I barged in and I asked, I have to talk to the inspector, call him. Then the police went and told, a lady has come. So he immediately, somewhere inside what he was up to, we don't know, he came out. And then we asked him, that you arrested, we heard. Do you want to, are you going to produce this boy in the magistrate's court? What time will you produce? Then he said, me and the court are the same. I don't have to produce, I'm not answering. He said, that is the error you are doing. You are not the same. If you look at the constitutional scheme, you have your limits, they said. And what is the basis on which you have done it? I'm not going to ask that question, but the way you have exercised power is not proper under the constitution. He said, so who are you? What are you? I said, I'm a law teacher and I've read constitution and I've read this cases. That time DK Basu was still not there, mind you, 1990, I'm talking about. So he did not know how to argue it. First of all, a woman coming and asking itself is half the battle won because they never are used to women asking such questions. And secondly, the questions as a lawyer. So he immediately told his team, call that boy, send him in. He said, I'm not going to spare this, that. I said, I will give an undertaking to make an NCR. And I needed that proof. So he gives the NCR, he sends the boy away, we had another vehicle, so the boy goes away. And in front of me, I could see the boy in inner clothes. So that was good enough for me. So I wrote to the DGP with this one. And overnight, I telegrammed rather, and overnight that inspector was suspended. So this is how the story goes. Then the boy goes and compromises because for him, this uniformed man coming and telling, I'm touching your feet, forgive me, this, that. He wanted to forget. I thought it is good for him also. But then I said he has to file a case against the person who has misled him to. Because there are these business interests and other interests. A lot of these things are there. And some people, for the sake of troubling others in India, that's very common. Sadistic outcome. But then, as a constitutional officer, you have a statutory officer, you have a duty, right? That is what I'm telling you about lack of training. Then he sought his forgiveness, etc. But what I'm coming to is that excessive use of authority or abuse of authority is the major challenge to the constitution. And with the powers vested under the criminal law, this is very much possible. That's why I'm saying from the moment police receive the information about offense and initiating criminal investigation and the protection of the accused. So very crucial times when the constitutional guarantees have to be protected. So the breaches of the constitutional guarantee in these 3 points: prosecution role, judicial oversight of fair trial zone, and police conduct. Very important. I had another case where we were on the other side of the accused, where the girl was killed, and we had to be tough. So that we played the opposite role because we knew where the gaps were. So we had to get the other party to bend to surrender and then to hand over whatever they had taken from the girl, etc. So so that the family felt good. We opened the case. The case which was closed, we opened by using the non-governmental organizations base and people's movement. The inspector and the police chief had to give explanation about why it had gone, and then we did the revision petition in the High Court. So this is how you, when you are looking at, when you're teaching to the students as teachers, I will give you action points, how you have to be empirically alert as well, so that they get these insights as the advocates. Let's go to the next slide. Next slide. So we have a manual which has been prepared by the judiciary for internal purposes. It is called as the Fair Trial Manual and Process. So in each stage of criminal trial, this fair trial concept, fair investigation concept has to be applied with the utmost compliance or due diligence about the human rights. Let's go to the next slide. So already first question that is asked is, what is fair trial? Why it is important? Fair means how a trial has to be ensured that it is fair. So it is the cornerstone of the justice society, and fair process, fair treatment is an innate human right. It's a fundamental human right. All of us are born equal and we need to be treated equally. So that is the fundamental principle which is embedded in the fair trial. And if the trial is not fair, as one of the judgments has revealed, Zahir Rashid judgment has revealed in 2006, it's a denial which results in injustice to all the stakeholders in the justice administration. The stakeholders such as the victim, the society, and other as the accused. So here, because of our treatment, the two become unequally treated and there is unfairness. And it's very important to see that there is respect for the work of the judiciary and work of the rule of law. So if you want to prevent crime, if you want to maintain law and order, then there is a decency of state behavior that needs to be seen. I gave you the story of the police inspector. Will anybody respect state if it continues like that? So the state cannot be complied with by the citizens by fear alone. The agency of the state or the behavioral phases of the state have to have a very decent behavior, and they should not resort to any extra legal method. So the confrontation I did was of extra legal approach that the officer had taken. And we have that in our legal system. We have an adversarial system, you all are aware, unlike the inquisitorial system, where there is examination of evidence, there is an argumentative approach, and accusational method we use. However, the word trial is not defined anywhere with CRIC also. This amended version, the new recast version, tries to make an attempt to define words such as trial, bail, and bail bond, among other things, which is the good point in this recast code. So what is trial? Trial is an examination of facts. So that's where evidence law becomes very important. In any case, to discover the truth. So the truth according to the purpose of the criminal law, that's where the Nyaya Samhita comes, the Suraksha Samhita comes, and Saksha Adhiniyam comes. All these three act on that issue to discover the truth, decide facts in the case, and then arrive at a decision of guilt or innocence. Now you understood what is trial, because there is no statutory definition. Let's go to the next slide. There is such a process of trial. What is the fair process? The fair process is the process that is certain, it is structured, it is declared, and it is known to everybody. Second, there is no abuse of power. So now we have to see the corresponding laws in our table of 311 and 165 of the Indian Evidence Act. You know that confession before the magistrate, which is corroborating the confession before the police officer. So all these points are brought in here. So there is no abuse of power because magistrate ensures that there is no abuse of power by looking at the confession statements made by the police officer. This is very important. Impartial judge, fair prosecutor, atmosphere of judicial norm. So there is there is a lot of empathy on the part of judges as well, which is neutrality on the part of the judge. Impartiality is a much contested virtue when we are talking about judicial independence as well. Independence is important to be impartial. But independence presumes that you are under no scrutiny or observation because you are assumed to be of highest neutrality and highest impartiality. But that assumption may be proven wrong in many times. I'll tell you about the case of the prosecutor. Prosecutor is the one who makes the first objection, right? And the minute that objection is made, the chances of under trials imprisonment continuing is very high, either in judicial custody or under police custody. So many times prosecutors act as if they do not know how to speak. Their glorious silence, many times, is sometimes it is explained by force, sometimes it is explained by innocence, sometimes it is explained by incentive. So prosecutor is a very important actor in the chain of fair trial. And one of my colleagues did a study on prosecution and he said that very poor behavior on the part of prosecutors. There is an analysis that says that in India the conviction rates are 17 to 27% between various states, if you see. Now, wherever conviction rates are low, in those states, prosecution qualifications, prosecution training is very low quality. For example, Maharashtra has, let me be very honest, Maharashtra has very high rate, very low rate of conviction. And we examined the prosecution training, and I was very familiar with the prosecution in Karnataka. So there is no selection of prosecutors like how we do, no examination, no subsequent training. There is no directorate which is very well organized as in Karnataka. So I was comparing the conviction rates. Karnataka rate is high compared to Maharashtra. But in Karnataka, I had faced this eerie silence of prosecutions in a couple of cases. I could not explain that reason at all. I was very fortunate in the case I was handling. My own classmate who was from the feminist movement was a prosecution judge. She fought, but she was facing so much of dissension by all governments because she was so proactive. So prosecutors being proactive and their coordination with the police is also an important issue. That would be your observation. The impartial judge, fair prosecutor, atmosphere of judicial norm are very important. This has been told in one Supreme Court decision. It's not my opinion. I observed it from that. So, judiciary should be competent. First, very important point. Competent means not only inherent competence to pass the examination, but good training also and independent. And it should not be having any executive influence, interference or control. And judiciary proactive should call for witness and material witness. Many judges don't do that proactive step. They go by what is presented before them. So imagine the outcome if there is not a very competent prosecution, not very proactive prosecution, no proactive judge and tainted investigation, what will be the outcome? And those who have the power, they will open it. We have had the infamous Shashikala case, right? Why was the case opened again? And what if the case is not opened? What would have happened? So this is where you see that the case was opened because of who? Because of the medium, because of the whole anguish that was expressed by our country through the media, NDTV investigation and many other things. So this is where when we teach our students, we have to make them aware that it is not just about the business of the lawyers. It's a social function that state is performing, and state is the champion of the society, and you know that constitution has ultimate sovereignty vested in the people, and state, the so-called state personnel are answerable to that we the people, right? So let's go to the next slide. So fair process is also about not only judge who is calm, but also prosecutor who is calm. And calm also means that bias against the accused should be eliminated, bias against witness should be eliminated, and judge should be the neutral referee. And if there is any reasonable apprehension of bias in the lower court, that needs to be identified by the higher court and proper fair process has to be ensured. We have this bias. Um, Judicial bias is a very infamous legend, right? Karnataka's Bhaktavatsala is a great talked subject. If you Google now, you will have these great expressions, one-line anecdotes, etc., which are indicative of personal opinion being taken as a judicial opinion or judicial wisdom. So, and these biases in doubted cases, I can show you so many examples where judges' own ignorance and bias has been there. Without naming, I visit somebody who has even gone to international level. I said that these urban girls who get married, go to husband's house, empty their house, and they leave at that house, and then they accuse of dowry, violence. So gender bias, class bias, appearance bias. So many types of bias can be there. That should be about that. And vulnerable witnesses to be protected, witness protection, which has been ensured in this. In saying that every state should have a proper scheme. Even the two areas, even women related, we have the Manodhaya scheme in Maharashtra. It is a scheme which has been rolled out by virtue of the Supreme Court decision, compensation for the rape victim. But not many states seem to be implementing it. How is it in Karnataka will be an interesting case. So within India itself, we have lots of research to do, and then we think of France and England and America. Within India, we have such diversity in terms of human rights index as well, human development index as well. So that would be a good way of how far witness protection scheme scheme approaches have been incorporated at the trial level and the high court level would be an interesting observation we can make. Next, let's go. So, what is the crux in our discussion? This red line. Even in the course of a criminal investigation, somebody being accused and a crime being investigated, the persons affected, they will continue to enjoy their fundamental rights, freedom, and then without any inherent, of course, there could be some deprivation of liberty, etc. For example, if you are in judicial custody or police custody, but then your other rights are there. What are those rights? Right to freedom from torture, which came as a Human Rights Convention's part, which has become a very important provision. So, freedom from torture. Torture is defined under our current Bharatiya Nyaya Samhita as well. Right to respect one's private life, because we put this on judgment privacy even within the prison, even within the custody or respected. The right not to be forced to testify against oneself, where do you find this? Or the right to remain silent. So, right against self-incrimination. Constitution, right? Article 20. Yes, right. The duty to keep records of investigation. This is vested on the state, corresponding duty to keep the record of investigation. Now, under the new Saksha Adhiniyam, the evidence covenant, and even under the Suraksha, which is criminal procedure codes covenant, there is a duty to video record the whole investigation process, which means it's not coming as subsequent to documentation, that is concurrent. So read those provisions very carefully and highlighting only those which are very significant for human rights and constitutional guarantee related protection. Let's go to the next slide. The next slide has a lot of material, but I'll quickly go through it. One is the dimensions of the Constitution and the Suraksha Samhita and human rights. These 3 points I would like to say. One is presumption of innocence. Very important. Criminal law's cardinal principle. That doesn't change, whether it is Macaulay or Mr. Amit Shah led provisions. It is the same, which is presumption of innocence. And this presumption of innocence is not just in the trial, it is pre-trial, it is during the trial, and even in reducing the burden of proof. And it is to be protected as human right. Okay, the presumption of innocence. However, statutory exception is there. Which are the cases? If you are looking at terrorism, anti-terrorism law, you are presumed to be guilty until you prove your innocence, because burden of proof is on the accused. So those are exceptions. But those they are exceptions, they are not the rule. So the general rule is, but even if there are exceptions, that doesn't mean you can violate their rights. Their burden is different, but their rights are the same. They are citizens of this country and they are protected by, and state is bound by the constitution to protect every person, not only citizen, but also every person. And then prohibition of government required. You know that no one should be uh, tried twice for the same offense. So that is also very important, 22. And then Kollavir's rather of basic was highlighted. One is knowledge of the accusation. Charges have to be read. First, the statement of the offense has to be done. Manner of conveying the charge, language, the precise way of conveying language. We know that in our country, large number of accused are not conversant in English. They may not be even conversant with the provincial language, so there should be proper interpreters or translators even during the trial. Right to open trial. Only our current Samhita provides for in-camera proceeding in case of women and children. Otherwise, in-camera proceeding is not prescribed. Otherwise, generally it should be open trial. And then free legal aid. If somebody is not able to different concerns financially, they can't afford. And right to secure counsel and provide legal aid. Law Commission report is there, 14th Law Commission report. And it is also highlighted in 3 versus State of Bihar that speedy trial. This is one change under this law. What is that change? Timelines are given. Within 44 days of charge sheet being produced before the court, the judgment has to. So time bound trial, and if the witnesses are not there, recorded statements can come. Now today I was reading about a private member's bill put in the parliament about right to internet. You remember Anuradha case in the wake of Kashmir, correct. Yeah. So in the Kashmir liberation, constitution liberation context, Anuradha had filed the case and she had said when the internet went down that everybody has the right to access internet, and the Supreme Court had upheld that. In the light of that, a bill is being passed. If that is possible, then lot of that's what I want to say, that it has a lot of answers from the human rights point of view, justice point of view, and constitutional point of view for delays, inordinate delays in the justice delivery as well. So this many press people have not picked up because they don't know the overall view of the law. So you all should write, to the press. It is our, you have a capacity, so please make little pieces in popular newspapers, television, which records on YouTube, from CMR's research and faculty cell, so that general public comes to know about the advantages of the approaches that we have taken under the new law. Just because people are biased against this government because of whatever reason, they don't seem to be looking at the good that is coming in their way. For example, look at the amendment made in the mental health law, or look at the approach that is taken. Even see, we thinking people, we are jurists, we are teachers. We can't be slaves to anybody. We are not blind followers like how Darshan's fans are coming and incriminating themselves. We are thinking people. So we do it irrespective of who is doing it. What is the good that is coming out is more important for us. And how it is answering a lot of questions. How it has for the first time brought into the body of the law. Not the first time. Earlier also we did the custodial death cases. Resumption, shifting of the burden of proof. Resumption came as the byproduct of this so-called natural case. So a lot of changes in the past also have come, piecemeal changes, but holistically last 20 years changes have not been incorporated into the law ever before, like how it has been done. So definitely human rights due diligence shows that with this law, we can have a hope of better protection of human rights and better protection of constitutional guarantees, especially with the timeline being shortened and electronic evidence being admitted. These are going to, and time duty being cast on provincial government, states also to help the witness protection scheme, etc. These are all very positive changes. And then we have General Article 21, which we have, and then which protects against the illegal warrant as well, and proceeding in the presence of accused or counsel and right to bail. These are already there, but some of the terms are not defined at all. Imagine Macaulay is India was where maybe 1% of the people spoke English who could have access to the legislation. They did not insist on translation. They did not understand India with provincial languages and the languages being spoken by millions of people, billions in some cases. So nobody bothered about this. So that kind of indigenization is aimed at in the current law, and thereby, in my opinion, it will accelerate the protection of constitutional guarantees and human rights if properly implemented with the cooperation of all the stakeholders. Let's go through this. Now, post-trial, we spoke about pre-trial in terms of investigation. Trial, we spoke about. Now, post-trial. A person is convicted only if law permits, right? Protection against self-incrimination during trial and post-trial also. The right to appeal. There is one law which I forgot to say, I was telling you, I forgot about it. Attempt to suicide is punishable. They say that it is adding injury to insult, right? Or insult to injury, that you want to die and you survive somehow. And then you are punished for that. So instead of therapeutic route, punishment route is prescribed. This is because it was all theocratic Church of England kind of agenda, Victorian. So under this law, it's very interesting that attempt to suicide is made non-punished. But if it is attempted suicide to threaten the state authority, to threaten the state action or interfere with the state action, then it is punished. So the purpose behind attempted suicide is seen as a very important point. Why it could be? Can you think about it? Have you read about Santara case? Because in our religious traditions, one's choice of leaving the body is always there. That is where Macaulay's problem is. He never understood this thing. Because the law came from top down. It did not came from bottom up. So when you sit with that unlearning of, all of us are Macaulay's slaves. We haven't done our real unlearning in terms of indigenous law. That's why I say that law teachers have to do community-based law reform exercise. When you go to the community as a stakeholder and try to understand their feeling, then you will know. Many times judges as part of that community have given certain judgments where they have taken a different view. That's why today we see those judgments coming into the fabric of the law, and that is where you can feel the difference. So this is one thing, self-incrimination, and that's why I remember that. And right to compensation for miscarriage is new factor. It's there. Of course, in many cases, especially in anti-terrorism law, also in Hyderabad and other places, right to compensation has been recognized. We had the famous Neelavati Behar case, where states, it is coming under constitutional torts, Pradhan Shah and other. Neelavati Behar was very interesting, where her son was also a domestic worker like her, and then that son was accused of theft, and then he was taken by the police. He was tied to a chair in the police outpost, and the next morning his body was found on the railway track. And the police investigation showed that out of the shame he had gone for a bio break, and then he ran himself under the train. But on behalf of Neelavati Behra, a letter was written to the Supreme Court. Supreme Court ordered a new investigation with a new set of officers, and then it was found out that it was not that by running over the train he had died. Time of death was noticed by the strangulation. At the time, his neck bone, he was strangulated and the neck bone was broken. So neck bone breakage was not due to train, but because of the force that was used. So it was clear that there was unwarranted amount of force which was used on him. So then the Supreme Court ordered compensation for the lady because he was only a member, and that compensation was kept as an amount in the bank, and then the police officers were dismissed from the job. So this is how we see that when new facts are discussed, partly or wholly attributed to this, not by charge but by evidence, on both ways, even in case of state. So such miscarriage of justice is also addressed. And balancing the dimension, before 98A, for example, if the lady wants to withdraw the prosecution, because in one of the judgments, court also has said it is a passive case. Or the woman may try to, the victim may, or survivor may try to reconcile for many other reasons, economic reasons, family reasons. Because they say that marriage-related issues are very cultural and social as well, not just legal. So today in Karnataka, if you want to withdraw a prosecution under 498, I was helping someone. It is virtually like climbing Himalayas, Everest. Because you go to one office, another office, prosecutor says, I don't have the powers, directorate of prosecution says, I don't have the powers. So all the way you go to Vidhan Sauda and loiter around that, then you get the secretary, home secretary to sign. And home secretary will not sign till he or she meets the victim or survivor. In victim it is different, victim's representative might be there, but survivor. No, that is in Karnataka. I didn't see the same in Maharashtra. Maharashtra also is very feminist. This point was not there. And in other states, don't ask me how the situation is. So this is the best practice of Karnataka. Now you see under the new code, the victim or the victim is victim's relative, victim is not there. Victim or the survivor have to be physically present in withdrawal and they have to be examined by the magistrate. They did not give that power to the magistrate earlier, because of which you had to go to Vidhan Sabha. Today, magistrate is given that power to verify. So this is the good point. So here you see custodial violence is another issue where so balancing damage in importantly GA and then balancing damage in extrajudicial killing in custodial violence is very, very important. So so it's one cannot convict in Sorabuddin case judgment also it was told that a conviction cannot be a moral conviction. There should be enough evidence to link you. We had that best case also, Dharma, distinctions made. So threatening the witness, entrenched prosecutors. So those points are to be very important. So these could be raised in the appeal. Transfer of the case or accused if they are not happy with the approach of the judge, that is possible. Presumption against fair trial was also done in the Ghaziabad Ph.D. So they said that the case has to be shifted. So you know the cardinal principle, 1,000 BTSK, but not one innocent be punished. And dishonest recording of court proceeding also is injustice. Noting without judgment. So this is very, very important. If the judge has made notes and has not given judgment, and taking those notes as the conclusive judgment and publishing is also wrong. So sometimes, people who go on appeal will bring these things to attention of the higher court, then it comes to God knows how many miscarriages of justice would have happened. That's why technical supervision in terms of recording of technology makes the judgment more transparent, and our current justice has opened up the television channels also to the proceedings of the court. Let's go to the next one. This is one important point in another cardinal principle. We saw fairness in process and fairness in trial, pre-trial, trial, and post-trial. Now, the next thing we can quickly go through is right to freedom from torture, which is a very important principle of human rights under the United Nations Convention. And in the Indian context, if I can show you a graph which I made way back in 2020, you'll be shocked the number of custodial deaths and violence. So there are so many decisions of the Supreme Court also. Violence, including gender-specific violence, the infamous Mathura case. Torture, as such, is violation of the Constitution. It is a civil wrong as well, and it's a crime as well. We have sections. And it attracts imprisonment, liability to compensate, and also there can be contempt proceedings. Actually, torture is an ever-growing body of law, the law against torture, and there are umpteen number of conventions. Torture in case of war, torture beyond war in the Geneva Convention. And then we have torture in case of refugees, torture in case of domestic law like this criminal law. Let's go ahead. So look at this 2020 and statistics. What is this? On remand torture. The on remand people being dead, Maharashtra, Madhya Pradesh, Uttar Pradesh, Rajasthan. And then people who are not on remand and killed in Gujarat, Maharashtra, Tamil Nadu, Rajasthan. So what does it show? This shows how custodial death is something and torture is something. Accusations of torture, and everyone doesn't even want to report. They would rather go to the medical hospital and then take their treatment and forget about it instead of bringing them to the book. But that's the wrong they are doing. Because these are personal pathologies of the officers who are involved, who have that approach. So they need to be booked and removed off the roster. So that is very important. Let's go to the next one. So now they are saying that even the uh, even when the seize and search operations happen, there has to be video under the new Suraksha Samhita, that is Criminal Procedure Code. So that's another welcome. And you know the famous DK Basu guideline, where it was clearly told that torture is the worst kind of crimes in civilized society. And then Article 21 is a provision which clearly articulates itself against torture. Courts have identified in all these. Across the living. So 163 of Criminal Procedure Code, in the earlier code, now we can see the recent provision, equivalent provision. So they also say that in the threatening conduct, statements cannot be adduced from the witnesses, and judges act as arbiters in terms of this. And also torture. Torture is not just physical; it can be mental torture as well. Police officers play this role. So many times, and custodial violence, and also in police custody otherwise. So in all these cases, it has to be ensured that it is free from torture. Then we say that without third degree method, how do we ensure the adducing of the truth? Then maybe that is not truth, or maybe that truth doesn't serve any purpose. So you always corroborate with forensic evidence. That's what is going our judicial system, because of these new laws, are moving into that kind of evidence. So they say that oral evidence, if you see the altered provisions, oral evidence, documentary evidence, and the evidence which has come through investigation. In all these three, you have to look at the first degree, second degree, and then always corroborate it with digital and other kinds of technical evidences. So veracity of the evidence, the evidentiary value, have put on a very firm scientific basis. That's why all over India now we also have a collaboration. CMR also has a collaboration. We have collaboration with National Forensic University, which is not just university, but there is a body of expertise interlinking with the university. So they created this infrastructure, it's still in the making, and then they brought this. Let's go on. So relevant I mentioned to you. So this has a strong basis in the international law, where a number of conventions have prohibited inhuman treatment, and right to compensation is available for those who are victims or survivors. Let's go on. So the other point is privacy. You know, Puttaswamy judgment has reiterated it, clarified it, and after that, we can see that as unenumerated right under Article 21. So it is right of respect to everyone's private life. Let's go ahead. In international law, we have Universal Declaration of Human Rights, which prohibits torture, Article 12, Article 17, International Covenant on Civil and Political Rights, and European Convention on Human Rights, Article 8. They have made the British government pay the compensation to a group of Pakistani people who were accused of terrorism activities. And in fact, they were the people who were working day and night to make their living, and they had no connection at all, and their privacy was disturbed every other time by the Royal Court. Royal Court is a horrible police force. So European at that time, the UK was under EU, so they were made to pay compensation to these youngsters who were accused or who were the suspects under the London bombing. Let's go ahead. So, right not to be forced to testify against oneself, or the right to remain silent, very important, right? You all know this under the Constitution, under Article 20, there are a number of case law. I'll stop here. Let's go to the next slide. Yeah, Maneka Gandhi is one of the landmark cases in this area. Next slide. I wouldn't explain more. So, yeah, go ahead. Go ahead. So, Universal Declaration of Human Rights under Article 11, International Covenant under Article 9 and 11, then Article 6 of the European Convention. Please read it. These are all available under Google. I will leave the PPT for you. Let's go to the next slide. So the duty to keep the records of the investigation, whose duty is that? It is the duty of the state officials, investigative authorities. It should be there with the investigation, with the police. Now with the seamless integration of data management and data, it should be very easy for everyone. Of course, the privacy is there, but some documents are public documents. Anybody can access and check. So the police also should be conducting it expeditiously, and it also lays down certain rules on record keeping, and that is available under the new code in a more spelled out way, where they provided more evidence of where to obtain the document, how to keep the document, and how to validate and certify those documents. Let's go ahead. So we have a landmark case, the Bhagwat Singh case, and we also have Nihil Kumar Ghosh case that not to police not preparing records swiftly can impinge on the fundamental right of the person. We are seeing these cases. There's a lot of public pressure in certain cases, and they should be fast in providing this and urgent forensic report. In our country, fundamental rights are violated mostly, especially when people are under trials or in judicial custody. If you ask me, this we have to correlate with prisoners' rights. I have had a situation in our college is 1 kilometer away from Yerwada prison, so we engage a lot in the work. Capacity of prison is 2,000, and invariably it has got 4,000, 3,500 people there. One of the judges, when I was doing this session for the Bangladesh judges in National Judicial Academy, told me about his experience. He was the Chief Justice of Madras. He said that there was, in his earlier assignment, he saw as the High Court judge a case when, High Court judges are supposed to visit these prisons and check as a committee. He saw that in one cell there were 8 people, and maximum possibility, even if they lined up beside each other to sleep, it was 6. So one would stand and take turn and allow the other to sleep. So they didn't have anything to protect themselves, or while standing, even you have a tendency to doze off. So they would use their bath towel to tie themselves to the window rod. This is the situation of our prisons. So when you're talking of human rights, even if they are accused or convicts, they are human beings. They have to lead a life of human being, not animal. So human rights in the prison is an issue by itself. There are plenty of literature which is written about it, about prisoners' human rights. So I mean, to be intact in a body, for example, foreigners, these Nigerians and others, they don't have any taste of milk or chilies. It gives them real attacks, So there is no separate food for them. Okay, they are accused, but they are human beings. They can't be killed indirectly. What cannot be done directly cannot be done indirectly. But our prisons don't have those kinds of diets, and prison diet is now under a lot of question in the court. Let's go to the next slide. In Karnataka, very interesting developments are there. So here also there is a time and place of all information to be recorded. This is further ensured. This is further ensured under the current version of our criminal procedure code because of insistence on information technology and cyber forensics, among other things. Let's go to the next slide. Now, this is very important. De novo investigation. We saw Nilabati Pera case is a case of de novo investigation, new investigation, re-investigation, or transferring the investigation. I had done this successfully in one case by going and arranging that the particular officer had been threatened because he allowed the accused to run away with the forged passport. So we didn't have much evidence, but we created evidence by media reports and bringing women and staging it. So you have to push these things. So power of re-investigation or transfer of investigation is to be done very judiciously. Not always. There has to be sufficient backing. And usually it is through the court of law. We did it with the police. But if the police refuse, then you go to the court of law, where the conscience of the court is shaken, where sufficient evidence. For example, investigation is complete, charge sheet is filed, and if it is completed, then they don't open. But during the stage of the charge sheet, if there is a doubt, then it can be done. Sometimes even after the charge sheet is filed, it's open. We have had de novo investigation in Jessica Lal case, even after the judgment has been pronounced. Nilabati Bera case, judgment was not there. It became a judgment because the investigation was accused to be not being fair by the letter that was sent. Every single accused. So these are some of the points. The distinction between fresh investigation, re-investigation, or de novo investigation, it is all based upon how the court is wording that order and who has approached the court. So now, let's go to the next slide. If the investigation is unclear, it is unfair, it is tainted, it is malafide, not so forth, then de novo investigation is done and also fairness. So we suggest that you are reading the Pujapal case, Pujapal versus India 2016 case, which gives you the conditions and basis of de novo or re-investigation. Let's go to the next slide. So there are many judgments related to fair trial and fair investigation in India. Quickly, I'll show you those judgments because of time. Please. One is Sakini Vasu case of Uttar Pradesh. The other is Mohanlal case. See, bias existing on the part of the police officer is one. Second is magistrate can pass directions to ensure proper investigation. Key point. Next slide. Ajay Kumar case, very important case, 2020 case. It is to be reflected from Articles 20 and 21 if it is not effective or purposeful or achieving the objective or not fair, then fair investigation can be ordered so that there is discovery of truth and no miscarriage of justice. Why fair investigation? So the points are very clear. Next slide. Yes, we can share our opinion. No problem. Arrest. Very important. Here also striking that balance of justice between individual liberty and societal interest is very important. Sometimes, arresting for the sake of arresting is not good, and letting the person loose in the society after arrest, after proper precaution, so that there is no upset of balancing in terms of criminal justice administration is very important. Many times police negligence has led to graver crimes. That also has happened. Let's go ahead. So while arresting, we know what all rights of the accused or person being arrested are present. So societal interest versus the accused interest, very fine balance. So accused human rights are there, but depriving the accused of his or her liberty is very important for the segment of the society. And bringing the accused back to that society without much harm to the accused and ensuring the safety of the society with proper precautions is important. You know what they are doing in Dubai and other places, financial crimes and other crimes. They put a buckle around their leg, which has got their, it is like a tracking. And wherever they go, it is known, especially in cases of repeated offenders, pedophiles. For the security of the society, that is important. In India, we have not used technology much. If those provisions, currently those provisions are there, so with those equipments and tools, it should be important. Now, this is the point I'm going to tell you. Overstaying under business and overcrowded business. It's a horrible situation. Have you come across judgments which are told that certain prisoners have overstayed? They have crossed the timeline of stay, which would have been levied as a punishment under the law. So in such cases, what do? We can't write it off. State should be making a payment of compensation available in such cases for prolonged deprivation of freedom. And proper criminological studies of bails and people under bail and how the bail has been exercised, how bail is not defined also in Macaulay law. Now, current law defines what is bail. So there is a need for very scientific study to see the impact and how the law has to be changed. I don't think in the law, current law is different, because current law is supposed to be recasting and updating, but not and repealing irrelevant provisions and indigenizing. But updation of the law can happen in future. Maybe every 5 years revisions will happen. So that time proper technological basis can be taken. However, the state is also trying to improve the prisons and other places. Let's go to the next slide. So this is reiterating the principles of human rights, that human rights are there in the international law, under the domestic law, and the constitution, that without an efficient guarantee of liberty and security, the protection of other individual rights becomes increasingly vulnerable. The minute their liberty is deprived because of the criminal law provisions, they become very, very vulnerable. See, in the prison, how women become vulnerable. Children, there was a statistics which was revealed from Bihar, where in women got pregnant after coming to the prison. Now, who could impregnate them? And even if there is consent, it can't be a consent. When you are under custody, it can't be a consent. And there was no systematic way of letting their spouses or friends, boyfriends inside. We don't have a provision as of now. Now we are making those provisions. Supreme Court has categorically made in certain cases that they could have a marital relationship within the prison under controlled conditions. Some prisons, I mean, everywhere we are making provision. Our current prison authority is a wonderful officer. He has taken big grant from Bajaj company, and 500 crore new setup is being made because it is a heritage prison. Gandhi was there, Ambedkar was there, Nehru was there. We have all those cells. If any one of you comes, we can show you those cells. But then they made a special this one so that they could have a little tea time with their family. They could have their interaction with the spouse. There is a separate bedroom arrangement and all of that. But it is all subject to evidence and structured process. So slowly we are opening up, but such unlawful, arbitrary denial of dignity, human rights, dignity, freedom, liberty, and protecting against vulnerability when they are deprived because of the legal provision is a very ambiguous, non-binary kind of situation. It needs to be the concern of the human rights, which current law has not directly done, but with more reforms in criminal justice administration, coupled with criminological study, it's possible. Let me go to the last slide. I think I've done enough and all the study materials are there. Fair and proper investigation are very important. Everybody plays a role in the chain, including investigating officer, judiciary, and post-trial result. Everyone plays a very important role. And nobody should hijack the investigation or wrongly influence the investigation because they have to protect the guarantees under the Constitution and also the duty of the state under Article 14. Is very important in terms of protecting the equality. Otherwise, it amounts to negotiating the equality. Let's go wrongly negotiate. So we all know that the beginning and end of the law is justice, genesis and end. So justice and law are intertwined. Therefore, a balanced approach would be not just a complete protection to accused in a blind way, and not just one fundamental right, but intra-fundamental rights. Let us be very proud of recalling Ajmal Kasab case, who was subject to fair trial, who was subject, I mean, somebody said, this is the word of Advocate Ramdev Malan, late Advocate Ramdev Malan, somebody confronted one of the students, young people. He confronted that why should we spend hundreds of crores in security when we are not that strongly a rich country and for one condemned terrorist? Ramdev Malan said that is the strength of our legal system. We want to prove to the West and to the world that we are capable of protecting the human rights of the person who has damaged us so much, hurt us so much, just to show that how fair our crime is, how we are protecting the rights of the individual. His diet was taken care, his mental health was taken care. Till the last minute, all his security, foolproof security was given to him. And we spent hundreds of crores in that. So that's a greater indication which shows that in intra-fundamental rights, even though it's a person whose life is going to be deprived according to the due process, that due process is followed or ensured by following previous article, Article 20, by giving him a lawyer, by giving protection, etc. And then it's not about thinking that all that judges do is correct. That pedestalization also to be regulated. And it has been, as Justice Bhagavati once said, our human rights jurisprudence in case of investigation and trial has evolved step by step. It's a creative interpretation which has led to case by case evolution in terms of human rights. So the last slide, next slide. There's one more slide. Yeah, this is action points for the audience. That is my last slide. So, three new versions of human rights we interacted in the beginning. Highlights are common language draft. The draft has minimized the legalese, you see. Okay, common English kind of draft as much as possible. Gender neutral, it has rate has been made gender neutral, 377 has been deleted. Attempt to commit suicide was threatening suicide and disrupting public or state is taken care. Child and human rights in case of polygamy or bigamy, the punishment to the husband is very clear, and then that independent thought judgment. Organized crime as addition, very important. Mob lynching has been taken care. Uh, alteration is more in the rather see there are three things I told color coded. Red is deletion, green is new provision, blue is alteration. So between red, blue, and green, blue seems to be maximum, alteration seems to be. That means basic fabric is not disturbed. And the criminal procedure code, Suraksha Samhita, has got more definitions, clarity with the technology. Actually, what I meant to say there was 510 sections of IPC are reduced to be 358 sections. Until the passage of the law, the old laws basis is taken for all the court proceedings, but from that day, new laws basis is taken. In the heart of heart, not much disturbance, but there is more reform and there is more focus and some new additions. Victim-centric approach, zero FIR, mandatory summary trial in 21. So this is going to reduce the burden of the courts. And the definitions are more curated. Delay is curtailed by e-summons. This is something that will come to civil procedure as well later on. Bail bond, etc. Timelines. And in absentia trial, somebody like Vijay Mallya can be tried. In absentia trial is facilitated. No withdrawal without hearing the victim witness protection scheme. And then we have the Saksha, that is the Evidence Act, where Section 57 is expanded, more accuracy, etc. Interestingly, here 531 sections have come in the criminal procedure code. That means the scope has been expanded and detailed and simplified in the language sense versus the 484 sections in the old legislation. And in Saksha Adhiniyam also, sections have been reduced, but extraterritorial evidence, very important. And criminal law also, right to file the case has been made possible even if the accused is away from it. So this gives new scope for strengthening the cyber. That's what we could see. Let's go ahead. So the last slide is about action point for law teachers. One is mastering this connection between the two laws, aligning them, and giving students the constitutional and human rights insights as we discussed today. Prison visits, reviews of the law, on your own, how courts are behaved and how you can look at it, how will you envision? Then second is comparative and international look in terms of India and other countries, extrajudicial killing, political rivalry, executive inaction, these points. And then also the issue of witnesses being threatened by the family members of the accused, or family members of the victim being threatened by accused side. So all these, how they have been handled. So student projects can be generated. You can generate, you are not just teacher, you are a researcher in the modern university. So how you can develop empirical research, because in law, empirical research is absent, case comments, then legislative analysis, and looking at this new law from the point of view of earlier limitations and failures, what is the hope of this new law for future? How you could see this law changing in future? You can collect your opinion of stakeholders on some of these altered areas or deleted areas, and then what are the prospects and challenges which become because of this new law. So this is how I would like to end my session by giving you enough food for your possible research, your possible way of making your class interesting, and also challenging the students to push the boundaries of their thinking towards critical insights and capability building to get into code-based careers and also any other kind of career and correlate with the emerging fields such as cyber law, biotechnology law, digital society, among other things. Thank you, sir, for giving the.
Thank you so much, ma'am. That was an enlightening and engaging session, and it was indeed very insightful. I'm sure we all have learned a lot from your lecture. Thank you so much for that.